Welcome back. I'm Joy Reid in for Melissa Harris Perry. It's been a week since a Florida jury delivered its verdict in the trial of Michael Dunn, the 47-year-old man who shot and killed 17-year-old Jordan Davis in Jacksonville, Florida in November of 2012. The decision of the seven women and 5 men on the jury who found Dunn guilty of attempted second-degree murder of Davis's friends, but were unable to reach a verdict as to whether Dunn murdered Davis, left many wondering, what were they thinking? Well, now we know, because this week, 2 of those jurors sat down for interviews where they talked at length about exactly what happened inside the jury room and what was going through their minds as they struggled to reach a consensus. In an interview with ABC News, juror number 4, identified only as Valerie, spoke about one of the first things the jurors did when they began their deliberations.
Page 25, start with page 25.
That was the page in the jury instructions that said that the use of deadly force is justifiable if Michael Dunn reasonably believes the use of force is necessary to prevent imminent death or great bodily harm. That is the language of Florida's controversial Stand Your Ground law that first attracted national attention after George Zimmerman went 44 days without being charged for shooting Trayvon Martin. And it was the part of the jury instructions that Dunn's defense attorney, Corey Strolla, explicitly told jurors to pay attention to during his closing argument.
He had no duty to retreat and had the right to stand his ground and meet force with force, including deadly force.
So although Dunn's defense attorneys opted against using Stand Your Ground in a pretrial hearing to exonerate him, we know now that the jurors considered it during their deliberations. According to juror number 4, it was an inability to reach an agreement on this key question of whether Dunn's use of force was justifiable that led to their inability to reach a verdict on the charge of first-degree murder. But there's another question that both jurors agree did not factor into their decision in the case.
How much of a factor did race play in the jury room?
Actually, none at all. Race wasn't presented in evidence, so therefore we couldn't use it.
White man shoots and kills a 17-year-old black boy. How could it not be about race on some level?
Sitting in that room, it was never presented that way. We looked at it as a bad situation where teenagers were together and words were spoken and lines were crossed.
So according to the jurors, race did not come up in the jury room because race did not come up during the trial. Prosecutors never introduced racially charged letters sent from Dunn while he was in prison awaiting trial, so the jurors never heard them in court. If they had, the jurors may have heard this musing from Dunn in a letter to an unknown recipient. Quote, "It's spooky how racist everyone is up here and how biased toward blacks the courts are. The jail is full of blacks and they all act like thugs. This may sound a bit radical, but if more people would arm themselves and kill these expletive idiots when they're threatening you, eventually they may take the hint and change their behavior." Michael Dunn is awaiting sentencing next month on the conviction of 3 counts of attempted second-degree murder and 1 count of shooting into a vehicle. But this will not be the last time a jury will consider this case in court. After last week's verdict was announced, Florida State Attorney Angela Corey vowed to try Dunn again on the outstanding charge of murder in the first degree. Joining me at the table are Marcus Mabry, the New York Times editor of the New York Times lead blog, Seema Iyer, a criminal defense attorney and former prosecutor for the Bronx DA's office, Khalil Gibran Muhammad, director of the Schomburg Center for Research in Black Culture, and Igor Volsky, managing editor of thinkprogress.org. So Seema, I have to come to you right away as our attorney of record at the table.
The Reid report, let's go.
Exactly, and ask the Dunn jailhouse letters, the one that I just read in the setup. Let me read a little bit from another one in which Dunn talks about thug culture. He says, "I'm really not prejudiced against race, but I have no use for certain cultures. This gangster rap, ghetto-talking thug culture that certain segments of society flock to is intolerable." Now, the prosecutor, John Guy, referenced this notion of thugs and said, hey, look at these other 3 boys, the 3 surviving boys who got on the stand. They're not thugs. He got that far. So why not introduce the letters?
I have no idea, Joy. In every one of my trials as a defense attorney, the prosecutor hands me a stack of CDs and says, listen to these. I will argue that they are relevant. If evidence is relevant, it comes into the trial. In this particular case, The words that Mr. Dunn wrote and the words that he uttered on those recordings are relevant. Why are they relevant? They go directly to the premeditation and the intent to commit murder, directly to that first-degree murder. I don't know why, Joy. This is the same conversation that we had during Zimmerman. Are they throwing these cases? Is this politically motivated?
You know, I want to take a listen to juror number 4, whose name is Valerie, and she talked about. Now, she was one of the people who wanted to vote for second degree. She was in favor of a vote for second-degree murder. Let's listen to a little bit of what she said about their deliberations.
Why were you and the others so convinced that Dunn was guilty?
We all believed that there was another way out, another option.
And yet, the actual jury instructions prevented them from using sort of that common sense reasoning to go to the next step, which was to say he's guilty of murder in the first degree, which would require spite and ill will, right?
The depraved indifference for murder in the second degree, but they would have had to have found him not guilty on the murder of the first degree to go to murder in the second degree, because that was a lesser included. And they hung on the murder in the first degree.
And so before Stand Your Ground was put into place in 2005 and signed by Governor Jeb Bush, this is the way Florida juries were instructed in cases like the Michael Dunn case, cases like the Zimmerman trial. This is what the instructions. The defendant cannot justify the use of force likely to cause death or great bodily harm unless he used every reasonable means within his power and consistent with his own safety to avoid the danger before resorting to that force. The fact that the defendant was wrongfully attacked cannot justify his use of force likely to cause death or great bodily harm if by retreating he could have avoided the need to use that force. So essentially, Khalil, based on what that juror said, we thought he had another way out, and those pre-Stand Your Ground jury instructions, this could have been a very different outcome without Stand Your Ground.
Absolutely. And I think we have to ask ourselves, do we want to live in a world where we know implicit bias shapes outcomes in high-intensity emotional situations? I mean, to the question of why didn't the prosecution enter this kind of evidence of Dunn's state of mind in reference to rap music, which, of course, is largely upheld by white consumers, why that kind of information wasn't used in this trial begs the larger question, how come an expert testimony wasn't given by implicit bias researchers? Because we've known for at least a decade, Jennifer Eberhard and Philip Goff at Stanford University have cited the fact that people, when primed with black faces, are much more likely to see weapons. They are either going to see guns or knives. Therefore, we have the basis for having a smart, even scientific conversation about how race functions in these kinds of circumstances. And Stand Your Ground, though problematic in every instance that we've seen, does not have to silence our ability to tease out and discuss the context in which race operates in our daily encounters.
I mean, you heard the jury say there, race never entered into the discussion because it wasn't part of the trial. But the problem is it's part of the law, because one of the big problems with Stand Your Grounds, and the problem that's baked into it, I think, is this idea that subjective belief rules, that your own biases, your own subjective feelings about someone,
right,
that's what matters, and you don't have to retreat, and you can, in some cases, cause very serious harm.
And it's interesting that you say that, because former State Senator Dan Gelber, there were very few votes, even Democratic votes against this law. It passed nearly unanimously. Dan Gelber, who was the House Democratic leader at the time, then became a state senator, he was one of the few who voted against it. This is what he said about why he did vote the way he did. He said, while in the Florida legislature, I strongly opposed the Stand Your Ground law because I believed it would provide defenses to people who had created the scenarios they sought protection from, or it would leave juries without the proper rules of engagement that ought to have governed predictable human interactions. By taking away from the jury the simple notion that people have an obligation to avoid the danger or retreat if they could do so safely, they were essentially authorizing stupid, venal, and in this case, often tragic behavior. Now, he wrote that, Marcus, about in reference after the Zimmerman trial, but isn't that the reality, that by saying, listen, jury, give complete weight and give deference to people's own personal, subjective views of the danger they were in, you're essentially sort of prompting people to just act without really thinking it through.
Absolutely. And when you read those pre-Stand Your Ground jury instructions from Florida, which said basically if there's another way out, you had to take it,
yeah,
you actually gave us the historical context for why Stand Your Ground came to be. Because there were people out there who said, well, that's ridiculous. If I'm threatened, I should be able to stand my ground and fire back. I don't have to retreat. So I understand that human reaction, especially those who want to have a tough on crime kind of way of looking at it, which is why so many Democrats supported it. The danger is to believe that that means that somehow there's going to be justice dealt in these sometimes murderous situations, as we've seen, is even when there's race involved, and there's almost always race involved when you're talking about people and races, even if you're talking about two African Americans, frankly, there could be race involved and perspective on race involved. To assume that that's going to be justice and it's not going to be racial bias injected in that situation is a historical ignorance in our country. Yeah. We don't live that way as Americans. I wish we did. I wish race didn't matter. It does. It matters in our justice system. It matters in how we see danger, as Khalil pointed out. Absolutely. And to ignore that is murderous, and that's what we've seen. And we're going to see it over and over and over again. This will not be the last time.
All right, stay right there, because when we come back, the mother of Jordan Davis is going to join us. We were all moved by what she had to say right after the verdict in the Michael Dunn trial.
We're so grateful for the truth. We're so grateful that the jurors were able to understand the common sense of it all. And we will continue to stand, and we will continue to wait for justice for Jordan.
The grieving African-American mother demanding the country look at the face of her murdered son and using the visual representation of his suffering and hers to demand that not just hearts but also laws be changed. That's what the world saw in 1955 when 14-year-old Emmett Till of Chicago was brutally murdered in Mississippi by two men after he was accused of having been flirtatious with a white woman. Till's mother, Mamie Till Mobley, exposed her grief and her son's mutilated body to the world. When she released the photos of his open casket funeral to the media, the shocking visuals attracted international attention to the victimization and vulnerability of African Americans in the segregated South and helped to galvanize the nascent movement for civil rights. Almost 6 decades later, the country watched the public grief of yet another mother who summoned the courage to act despite a heartbreaking loss. Sabrina Fulton, the mother of Trayvon Martin, continues to honor the life of her son with her activist work to ensure another mother will not have to carry such a heavy burden. And yet, her work remains undone because the name of another mother has now been added to her cause. In the wake of the shooting death of 17-year-old Jordan Davis, his mother, Lucia McBath, joined the fight for gun law reform as the national spokesperson for Moms Demand Action for Gun Sense in America. And she joins me now from Jacksonville, Florida. Lucia, it's wonderful to talk with you again. I want to start by asking how you're...
Thank you so much.
Well, I want to start by asking, and I'm sure all our viewers would love me to ask, how you're doing.
Taking it day by day. Yesterday, I was able to have a little bit of a rest and relaxation with my family. We got a chance to go to Orlando just to breathe a little bit. So just taking things day by day.
And I mean, you spoke so eloquently, obviously, during the trial, and I think everyone has been really amazed by your courage and your poise and all of this. The next step for you, and something you've been involved in, is this issue of gun laws. How do you plan to tackle that? And give us just a little bit of sort of your strategy going forward with Moms Demand Action.
Working very actively as the national spokesperson for Moms Demand Action for Gun Sense in America, working collectively with all the mothers and the families across the nation as we bring to light to the legislatures, the state legislatures, civic organizations, businesses, universities and administrations, letting them understand what the gun culture is in our country, how it is devastatingly affecting each and every state, and getting citizens to understand and know that they have power and authority to make the change to eradicating a lot of the gun laws in this country that have been designed basically to just... And it's just really sad what's happening in the country is that people are not able to freely walk their streets and live without the fear of guns, without the fear of violence. And so that is what we do with Moms Demand Action. We actively work within the nation to bring to light the gun culture in the country and make the changes in the laws.
And I mean, have you had any outreach? Have you heard from any of the proponents of Stand Your Ground? I know you're not a Florida resident, but any of the state legislatures and state legislators in Florida who are now being asked to consider changing that law, have any of them reached out to you?
Not personally, other than State Senator Corn Brown, but having gone to Tallahassee before and testified before the legislature there, was just a little dismayed because constituent after constituent after constituent basically spoke and said that they were very happy with the laws in the state of Florida and that they were working for the citizens in the state of Florida. And that was very disheartening to hear that.
Yeah, and I mean, I want to talk just a little bit about sort of the trial itself. I mean, you have now heard some of those jailhouse calls, and I understand letters that Michael Dunn sent from jail. Did it surprise you that none of that was released at trial or used in the trial?
Well, you have a time frame in which evidence can be introduced, and of course, Judge Healy did make consideration for those pieces of evidence, but they were released after we had already begun trial. So some things were not allowed in evidence at that time. We're definitely aware there'll be more evidence that will be allowed in the trial for Jordan coming this spring.
And what about your response to the jurors, two of whom have come forward and said that race played no part in the trial, it wasn't brought up in trial? Do you believe that race was a factor in Jordan's death?
We know that race is an element of our case, and that cannot be denied. I can't personally speak for those jurors. Maybe they really did believe and think that race was not an issue. I firmly believe in what I've seen across the country, and particularly with the way the laws are being used in the state of Florida. It is my belief that at some point in time, there had to be some thought of race.
Yeah, well,
but I cannot speak, particularly for those jurors.
Right. Well, Lucia McBath, I think I join everyone in commending you. You are obviously a very strong woman. You're doing a lot for other moms so that they don't have to join the horrible club that you've been not voluntarily placed into. So thank you so much for your advocacy and for being here today.
Thank you so much for having me.
Okay, thank you.
Thank you.
All right, and up next, despite the Dunn